I'm John Malcolm. I am the chairman of the Criminal Law Practice Group, so I welcome you all here today for what should be a really interesting and provocative program. I really just wanted to take a moment to put in a plug for our practice group. Those of you who are here who would like to find out more about our activities, who would like to be engaged, I would encourage you to reach out to Dean Reuter. You can contact me, again, John Malcolm at the Heritage Foundation. We would love to get you involved in our activities. And now, without further ado, let me turn it over to our moderator, Judge Ray Randolph of the D.C. Circuit.
Thank you. I wonder if I should be called a navigator. I kind of like that better than moderator has visions of Magellan and Christopher Columbus and all the rest of it. But anyway, the subject of our discussion today is an old one, but it's a recurring one. There are interests of the press in gathering information and reporting on the operations of the government, and there are the interests of the government in preserving national security, enforcing the criminal law. I think all of you have access to the topic itself as described, and I'm not going to go any further. I said it's an old problem, and I just want to share with you one thing, that in 1971, I was in the Solicitor General's office when an important case arrived. The Supreme Court granted certiorari on a Friday morning in late June and ordered the briefs to be filed by 9 o'clock Saturday morning, and then held the argument at 11 o'clock on Saturday in an extraordinary session. The case was the Pentagon Papers case. And I wrote part of the brief without having seen the 47 volumes, but the issue, one of the issues that our panelists will be discussing is an issue that was left open in Pentagon Papers, and that is, even though you can't get an injunction because of the prior restraint doctrine to prevent the newspapers, in that case the New York Times and the Washington Post, from publishing, that didn't necessarily mean that the publishers could not be prosecuted under, at that time was the Espionage Act, for revealing classified information. And that question has recurred again and again and again, sometimes in cases in our court, and certainly in the headlines with people like Mr. Snowden and Private Manning most recently. Anyway, our first speaker is probably familiar to all of you. Eugene Bullock is a frequent participator in the Federalist Society programs. And among other subjects, he teaches free speech at UCLA Law School. He's the author of numerous articles and a First Amendment casebook, and also the most extraordinary teacher's manual I have ever seen. It's accompanying his casebook. I think it's twice as long as the casebook, isn't it? Anyway, Professor Volek clerked for Judge Alex Kaczynski and then for Justice Sandra Day O'Connor. And he's probably more well known as the founder of the Volek Conspiracy, a weblog that attracts some 20,000 visitors every single working day. Professor Volek.
Thank you. I should have some PowerPoints, and there they are. So I was told that there are two things going on here, and I'll talk about them both. Legally speaking, they're very separate. Practically, they come up often in very, very similar contexts. So the first thing is the news gatherer's privilege question. Now, the leading case on this, of course, at the Supreme Court level is Brandsburg v. Hayes, although it turns out the law of the news gatherer's privilege is quite a bit different than, ends up being quite a bit different than you'd expect from reading just the case. So the question in Brandsburg v. Hayes was whether journalists should have a privilege to refuse to reveal their confidential sources. And they said, look, we need to have this privilege because otherwise it would burden our communication of the news to the public because people would be much more reluctant to talk to us. And the court said, no. The majority, 5 out of 9, but 5 is all it takes, said no. You have the same duties as any citizen does to testify about possibly relevant information, especially in the context of a grand jury subpoena, which was the issue there, and no privilege. Now, the dissent said there should be a privilege. Actually, the one justice dissenting, Douglas, called for pretty much an absolute privilege. And then 3 justices, Stewart, Marshall, and Brennan, called for a privilege that basically sounds in strict scrutiny. Disclosure is required only if there's a compelling interest, and there's no less restrictive means of getting the information needed to serve that interest. You'd think that would be it, but there was this concurrence. Not a concurrence in the judgment, just a concurrence of somebody who joined the majority fully, Justice Powell. And he said, well, I just want to repeat what the majority is saying, and it did say something like this towards the end of its opinion, although Powell elaborated on it. That there are protections for newsmen. There's to be no harassment of newsmen, which sounded in context of the opinion like no going after newsmen just in order to, for example, out a source who might be a government employee whom you want to fire, or somebody else you might want to retaliate, or for that matter, harassing a newsman because you don't like what he's saying about you, so you call him in front of the grand jury as kind of punishment to take up his time to ruin his relations with the sources and the like. Investigation must be in good faith and with a legitimate need. The connection to the investigation must be more than remote and tenuous. Note, these are the kinds of things that in principle you can get without First Amendment scrutiny under just normal standards related to subpoenas, that in principle you could quash such subpoenas based on these kinds of factors. And this is where, well, that's very interesting. This is where the opinion got even more potentially confusing, is that the proper balance between freedom of the press and the obligation of all citizens to give relevant testimony with respect to criminal conduct must be struck on a case-by-case basis. So it sounds like, and one thing you might say is, well, that's still somebody who joined the majority opinion, so there's no privilege. Or you might say, well, because he was a necessary vote for the majority opinion, what that means is that there is some kind of modest privilege sounding in kind of a slightly more aggressive enforcement of subpoena standards. Yet several circuit courts basically said that Powell's opinion calls for something like strict scrutiny, which is funny because that's what the dissent called for. And the one thing we know about Powell's opinion is he dissented from the dissent. He could have given the dissenting justices the necessary 5th vote to basically make it a majority, subject to Douglas's more aggressive view, but he didn't. He had more in common with the majority than the dissent, yet for quite a while the dominant view among circuit courts was, yes, there is a privilege, notwithstanding that. Surprising, and in some measure there's been a retreat from that. The recent opinions have cut more in favor of taking the view that in fact there is no newsgatherer's privilege. So that's the issue at the First Amendment level. Note incidentally that even under a strict scrutiny approach, the newsgatherer's privilege might be actually quite modest in scope. In those cases we've been hearing most about where the person is being the journalist is being asked to testify about a source of a leak, of an allegedly illegal leak. You can think of there being 2 general classes of cases involving newsgatherer's privilege. The first class is when somebody calls a reporter and says, look, I'm not involved in a crime, but I know something about it. I'm a government employee. I've seen evidence of fraud. I'm going to pass this along to you, but you got to keep my name out of it because otherwise I'll lose my job. Otherwise I might be harassed in various ways. I'm not going to be prosecuted because I'm not involved in the crime. I'm just a witness, but I don't want to get involved any more than I need to. That's one class of cases. And in those cases, maybe strict scrutiny would provide quite substantial protection for the reporter and for the source. But if the second class of cases is when somebody is leaking something to the reporter, so the reporter is really the only precipient witness to, assuming the leak is criminal or even tortious, to the underlying bad act. So there, under strict scrutiny applied at least in a non-fatal in fact way, you might say there is a compelling interest in enforcing the law banning the leaks. And while in principle you might be able to find other evidence about the leak, very little evidence is going to be as persuasive to the jury as the other side of the leak coming forward and saying, yep, he called me, he told me, that's what happened. So in principle, for the second set of cases, this qualified privilege, even if you read Powell's concurrences endorsing it, or even if you adopt the view of the dissent, wouldn't actually amount to much. So that's the First Amendment picture. Some circuits accept a qualified privilege, although again, not clear how much it would come up in the leak prosecution cases, how much weight it would carry it. Other courts, I think, with a more correct reading of Brandsburg, reject it. Can I get the next slide? Could I have the next slide, please? Great, thanks. Color is a little bit work better on my computer than here. One thing, though, what I'm trying to do in this table, to the extent you can see it, is to suggest that if you step back from this and look at it as a matter of broader First Amendment law, this question of when the government is entitled to every person's evidence is actually pretty complicated. So, for example, and this is what the dissent stressed, there's a long line of cases involving expressive association, membership in association, which said that actually, yes, strict scrutiny is what's required in order to get information about your First Amendment activity in the form of joining the NAACP or joining any other association. Likewise, as to contributions to political groups, court has routinely said that the strict scrutiny is required for such disclosures, although their strict scrutiny has often been satisfied, Justice Thomas being the one most prominent dissenter. When it comes to reading material, there are only a couple of cases involving subpoenas of books people have read. There was one famous one involving Kramer books in the Clinton-Lewinsky matter, in which courts, the two courts that I know of that have considered this, have actually also applied strict scrutiny. I say asterisk because that's lower court case. Now, when it comes to other situations, though, it's quite different. When it comes to identifying anonymous commenters, lower courts have generally applied some kind of heightened scrutiny. But when it comes to other things, for example, tenure review letters, there's a case, EEOC versus University of Pennsylvania, which rejected any heightened scrutiny in that kind of situation. Even though there, too, the concern was that revelation of the identity of people and their content of their speech is going to interfere with speech and is going to deter speech, just as was the case in NAACP cases. Likewise, in the editorial board discussion case, Herbert v. Lando, the court rejected a privilege, even though the concern likewise was that if you can't communicate confidentially, people will communicate less candidly or perhaps not at all. Likewise, in the standard case, if somebody wants to subpoena your communications with your friends, for example, you're being prosecuted for some crime, the government wants to show motive, so they call your friend to the stand to testify about what you told him about it. And he says, well, I don't want to testify. That would chill speech between me and my friends. Sure, it would chill speech between you and your friends. You got to testify in any case. So that's what makes it actually a little complicated to figure out when you've got the newsgatherer or source communication case, where to fit it in. Brandsburg, I think, has told us that, but that's, I think, made it a hard and 5-4 case. Next slide, please. Now, there's a remaining question about what about the common law privilege? Not a First Amendment mandated privilege, but a common law privilege. Remember, in federal court, privileges are, by federal rules of evidence adopted by act of Congress, are a matter for continuing development of the common law. So Congress has specifically authorized, in fact, required courts to develop privileges in light of the common law. Excuse me, through the common law method, which is to say, authorize them to create new privileges as well. In Brandsburg, the court rejected that, and some recent courts have said, well, Brandsburg disposed of that, and I think that's a reasonable point, but there's still the question of whether that should be revisited, common law being that way. Here's the picture. 33 states provide for such a privilege. That's maybe even 35 now, depending on, actually, I'm sorry, I think it's probably 33. And that's a factor in favor of recognizing such a privilege as well. In other states, at least some courts have recognized such a privilege as a matter either of state constitutional or common law. Of course, they're quite different. Some are absolute, some are qualified, some are for all speakers, some are limited to professional journalists, however one defines that. And there are analogies: attorney-client privileges, psychotherapist, patient privileges, clergy penitent, spouse privileges. Of course, how far those analogies go, it's hard to tell. I mean, these are only analogies. They're not identities. We're not talking about attorneys. We're not talking about psychotherapists. At the same time, you can make plausible arguments that there are similar societal interests in fostering candid communication that yield a justification for a privilege in the journalist source context as in others. Note, though, none of those privileges, the privilege that I identify, excuse me, I shouldn't say none, but many of them, especially the most prominent one, attorney-client and psychotherapist-patient, are not absolute. So, for example, there's a crime-fraud exception. It seems to me that if you are trying to leak documents in violation of the criminal law, and you're calling up a journalist to kind of help you commit that crime, that would fit very neatly into a crime-fraud and exception, if there is to be such an exception to any common law journalist privilege. Likewise, more broadly, the journalist is the only percipient witness in many of those cases, of the leak cases, and that, it seems to me, cuts in favor as a common law matter of carving out an exception in those situations. Shall we, next slide, please? So let me just close by talking about the second category of things, which all often arise in the same situation. So let's say that something is leaked to the journalist. One question is, can the journalist keep the source out of jail, in a sense, by not revealing his identity? The second question is, can the journalist keep himself out of jail? Now let me just give you the big picture issue here. This comes up when there are leaked government secrets. Could be national security, could be otherwise, but it could be corporate secrets. Violation of a duty of confidentiality, duty of loyalty. Could be trade secrets. Trade secret law, at least in principle, if you look at black letter summaries, penalizes downstream distributors and not just those who violate their own duty of confidentiality. Professional confidence is what happens if a journalist publishes something that was wrongly leaked to him by a lawyer or by a psychotherapist. Illegally recorded cell phone conversations are not exactly the same, but a close analogy. That was, of course, the Bartnicki v. Vopper case, in which the court said, well, innocent, as it were, I shouldn't say innocent, that's not quite precise, downstream distributors who weren't involved in the original illegally recorded conversation, just showed up in their mailbox, they are immune, at least when the matter is of public concern, or maybe of exceptionally great public concern if you listen to the concurrence. You could imagine something similar with unconstitutionally gathered evidence. What if it's not a violation of criminal or civil law, but of the Constitution? What if there's something that's gathered, violation of the Fourth Amendment, and a newspaper learns about that and publishes that? Could that lead to either criminal persecution, or in many of these situations, it could be in principle a civil claim? Next slide, please. Now, the other thing we need to think about here, and I'm not going to give you an answer, I don't know what the right answer is, and even if I did, you probably wouldn't believe me. But I just want to make sure we see the big picture of how it all can come up. Sometimes you get a situation of a reporter gets documents out of the blue. That's what seems to have happened in Bartnicki v. Vopper. You still have this interesting question, especially if it's an original document and not just a copy. That could be literally receipt of stolen property. It could be actionable in other ways. In Bartnicki v. Vopper, it was civilly actionable and sometimes criminally actionable. The other extreme, imagine a reporter solicits documents from a source, calls up and says, hey, I hear you know something about this. Tell me. And it's perfectly clear that the reporter knows that it would be illegal, either criminal or tortious. Thank you. Could be soliciting crime, could be conspiracy to commit a crime, could be aiding and abetting crime, could be intentional inducement of breach of contract. Or civil conspiracy, that could be a pretty serious possible liability. And then, of course, a lot of things in between. You get a document, you call the person to confirm, then you have a conversation. In the conversation, other things come out. How much of that is induced? How much of that is not induced? Very hard to tell. So these are all the issues that come up. A lot of this is the bread and butter of everyday news gathering. And the question is, what should be done about it?
Thank you. One time I was moderating a panel, a noted Harvard law professor was speaking, and I kept handing him notes, and unlike Gene, he didn't sit down. And he finally turned to me and said, the judge is getting nervous, he's looking for a gavel. And I said, actually, I was looking for a U.S. Marshal. Our next speaker is Adam Liptak. He's been the New York Times Supreme Court reporter since 2008. He's a graduate of the Yale College and Yale Law School. He's practiced law. He's taught media law at UCLA Law School, at the Yale Law School and the Columbia School of Journalism. In addition to covering the Supreme Court, he's written many articles in law reviews and publications such as Business Week, Vanity Fair, The New Yorker, and other national publications. And we're very happy to have Mr. Liptak with us.
Thank you, Judge. So I did, it was a while ago, but I used to practice in this area. And I remember once being on a panel back at the New York City Bar, probably in the 90s, and Judge Mukasey was still on the bench. And I had looked up, did a little research, and I saw that Judge Mukasey had been a press lawyer back in the day. Patterson Belknap, am I right about that, representing the Daily News? And I said to him at the little, dinner beforehand, God, it must be so good for us in the press to appear before a wise judge like you who really understands our arguments. And he said, wrong question. Question is, how much does it hurt you? And I fear I have a little bit of the same thing, because if you really know your arguments, you know the weak spots in your arguments. And I think I'll start with Eugene's topics in reverse order, and on some of them I will say just what you'll expect me to say, and on some of them I might make some admissions against interest. So I think there are three basic propositions here. And in the great press cases of the 60s and 70s, at a time when the press really had a lot of power, prestige, authority, and was thought to be responsible, mature, someone you could deal with. You may not like what the editors did on every occasion, but you could talk to the New York Times Washington bureau chief. We weren't living in a WikiLeaks era, but in an era where there was somebody on the other side of the discussion who was part of your milieu. And in those cases, we almost ran the table on everything we cared about. In Pentagon Papers, we more or less established the proposition that you cannot stop the publication of truthful, newsworthy information that citizens might like to hear about in order to govern themselves in a democracy. So no prior restraints. And I understand there's always a little bit of give and always a little balancing, but that's certainly the message we took away from Pentagon Papers, no prior restraint. Other cases leading up to Bartnicki seem to say, more or less, that there can also be no subsequent punishment of press publication of truthful and newsworthy information, even if somebody violated the law somewhere, so long as you were something like the passive recipient of the information. So no prior restraint, no subsequent punishment, so long as you were, Eugene used the word innocent, passive. You didn't go and break into somebody's office and steal the stuff. You didn't hack somebody's phone. Somebody violated some obligation of that other person, gave it to you. And then in Brandsburg, amazingly, we got within one vote of running the table, of establishing what the First Amendment doesn't seem to me to say, that we have a special privilege against subpoenas not available to others. So I think the First Amendment does say this. It says no government censorship of at least speech about politics that's truthful and useful in self-governance. But to go further than that, and say that the First Amendment has in it a privilege that we don't have to obey subpoenas when we are sometimes the sole eyewitness to a crime, that's a bold proposition, and I really congratulate the press lawyers, myself included, for baffling the courts with this proposition for decades, for really essentially turning the dissent. Plus, everyone talks about the Powell concurrence, and it is a little confusing, but it's very, very brief. It's 2 or 3 paragraphs. And to build on that foundation, the idea that there's constitutional protection, was quite an achievement, and sooner or later we were going to be called on it, and it was partly a function of the decline of our power and prestige that we were called on it, but I don't think that was wrong. I do think that as a matter of prosecutorial discretion, as in the Justice Department guidelines, the statutes that Eugene described, federal common law, as Judge Tatel sketched out in the Judy Miller case, where at least you get some balancing, where, what you really want in these cases is to get before a judge and make your case that this was a really important publication, and as Tatel put it, you balance how much harm the leak caused versus how much good the publication did, and in some cases, the good will outweigh the harm. So anyway, I think it would be wise to allow sensible balancing and to avoid needless confrontations between the press and the government. And I think the place to look for how this works and how messy and unruly it is, but how this really ought to work, is in Alexander Bickle's great book, The Morality of Consent, where he welcomed what he called the contest between press and government. The basic idea is it's the government's job to keep the government's secrets. And if somebody violates an oath to keep a secret, by all means, punish that person. But the press, if it finds out what it can, without itself committing a criminal violation, and publishes what it believes will aid citizens in a democracy to govern themselves, should be left alone. So, and here's what Bickle says. This is not an arrangement whose justification is efficiency, logic, or clarity. Its justification is that it accommodates power to freedom and vice versa. It reconciles the irreconcilable. He acknowledges that this is, quote, an untidy accommodation, but he goes on to say the accommodation works, but it works well only when there is forbearance and continence on both sides. It threatens to break down when the adversaries turn into enemies, when they break diplomatic relations with each other, gird for and wage war. Thanks.
Adam mentioned Alexander Bickle, who was truly a great constitutional law professor, and as a historical aside, he argued for the New York Times in the Pentagon Papers case. And I remember, I was there, and I remember one exchange where he was pressed again and again and again with a hypothetical, and the hypothetical was, let's suppose that what the New York Times is printing would result in the deaths of many servicemen. Do you still say that the courts can't enjoin the New York Times from printing it? And he finally was backed to the wall, and his reply was something to the effect, he said, I have to admit that my humanitarian instincts in that type of a situation overcome my devotion to freedom of speech, which I thought was a great answer.
And so offensive to some, the ACLU filed an after-argument brief objecting to that answer.
Our next speaker is well known to all of you, I'm sure. Michael McCasey is now a partner at the Debevoise firm in New York City. He served as a distinguished Attorney General of the United States from 2007 to January 2009. Before that, for 18 years, he was a district judge in the Southern District of New York, becoming chief judge in 2000. During his tenure on the court, he presided over many notable trials, including the terrorism trial of the blind Sheikh Omar Abdel Rahman. Among his many awards, he's received the Federal Bar Council's Learned Hand Medal for Excellence in Federal Jurisprudence. General McCasey.
Thanks. Before I get into where all of this has wound up today, I think maybe it's useful to go back a little bit and figure out what the founders who wrote the document on which folks base all these arguments for openness were really all about. You may recall that the Constitution itself was drafted during the span of a baseball season in Philadelphia with the doors closed. Not only did they close the doors against outside inquiry, but they barred any report of what was going on inside, and they well understood the need for secrecy. Even in the document itself, when it came to drafting a section relating to the obligation of both houses of Congress to publish their reports, they carved out an exception for those matters that it was necessary to hold confidential. Even Patrick Henry, who was an anti-federalist and felt that not enough, the new government was not characterized by enough openness, even with a Bill of Rights in place, wrote, I am not an advocate for divulging indiscriminately all the operations of government. Such transactions as relate to military operations or affairs of great importance, the immediate publication of which might defeat the interest of the community, I would not want to be published till the ends which required their secrecy should have been effected. That sounds almost quaint today, but in point of fact, there have been virtually no prosecutions for and there have been actually no prosecutions for publication of leaks certainly in recent memory, and I don't believe ever. There were, not that there haven't been leaks that threaten national security. During World War II, one of our newspapers leaked the fact that there were plans by the Roosevelt administration to come in on the side of the Allies, and Germany acted on those plans by declaring war on the United States shortly after Pearl Harbor, and saved us the trouble of waiting for a German attack. You might say that was actually a salutary leak. A potentially non-salutary leak involved a leak that we had read the Japanese code. A grand jury was actually convened to investigate that leak. It never returned an indictment because the Japanese apparently either didn't subscribe to the Chicago Tribune, or else, and more likely, were so hubristic about the validity of their code that they couldn't believe that we could have solved it. And so the government declined to prosecute. We've come a long way since then, and I'm not sure we've come in a useful direction. Professor Biggle talked about what happens when the two sides become, among other things, incontinent. And that, I think, aptly describes the nature of what goes on today. If you look at the Snowden leaks, that is a working definition of incontinence. And yet, there is in the atmosphere kind of an unwillingness to go ahead and prosecute people who do that. I think in large measure because the people who would be doing the prosecuting, and who, by the way, are prosecuting at a rate that is more substantial than in any administration before. I think they've got, 6 or 7 leak cases pending now, which is 6 or 7 more than we had. And I frankly envy them for that. I would have liked to have had that record. The trouble is that all of this is being done by an administration that, for example, at the time of the bin Laden killing, went out and boasted about the trove of information that had been discovered in bin Laden's hideout, and of course warned anybody who had been in touch with him that they would have to alter their method of operation, identified SEAL Team 6 as those who had carried out the operation, and thereby put a target on SEAL Team 6, and may very well have been responsible for the fact that several members of that team were killed in a subsequent terrorist operation. Disclosed that there had been a Pakistani physician who had participated in an attempt to gather intelligence about bin Laden's residence, with the result that that doctor is now doing life in jail. Fast forward to the Stuxnet virus, where we got leaks of information about conversations in the Situation Room in the White House, disclosing that the United States was involved in putting the Stuxnet virus into the Iranian centrifuges. A piece of timing that was really unfortunate, because it came only a few days after a U.S. military officer said that a cyber attack on the United States would warrant a kinetic response. When you put those two things together, what he was saying essentially was that the United States had committed an act of war against Iran. The operation that resulted in this, more recently, in the seizure of Abu Anas al-Libi was leaked to a fare thee well, to the point where people were getting calls the night before it went down, asking whether something was up in Libya. Under those circumstances, I think there is what we lawyers call a standing problem for an administration to press leak prosecutions. It's not a legal defense by any manner or means, but it makes the atmospherics a good deal more difficult. That said, I don't think that we have any need for any of the shield statutes that have been proposed. I noticed that Adam stayed away from that. Thank you. because what they ultimately come down to is a set of determinations by a judge as to a balance between the harm that could be caused by the leak as compared to the good that could be done by it, which is a balance that involves comparing complete imponderables, and the comparison is being done by somebody who's got absolutely no training, no background in it. And in the end, of course, under all of these statutes, the reporter gets to do exactly what the reporter gets to do now, which is to refuse to disclose the information if he decides that the judge has struck the balance the wrong way. There's no requirement that the information be disclosed to the court before the litigation proceeds. So I think we don't need those statutes. So far as prosecutions, there is in force an espionage statute that I think fills the bill nicely. It says that whoever with intent or reason to believe that it is to be used to the injury of the United States or the advantage of a foreign nation, and that would include an entity that is not a nation, discloses information relating to the national defense, shall be punished by death or by imprisonment for any term of years or for life. And in an appropriate situation, there is absolutely no reason why that can't be used. I don't think we need more statutes. I don't think we need a shield statute. I think what we need is some common sense and some discretion on both sides. At the Justice Department, I will tell you that there is a whole set of procedures, including a requirement that the Attorney General approve any subpoena to a reporter before it's served. So, in essence, the position of the dissent in Brandsburg has been carried through administratively by actual practice within the Justice Department. I think what we don't need is more statutes or procedures. I think what we need is common sense and restraint on both sides. Thanks very much.
Thank you, General. Our next speaker is Eric Friedman. He is the Maurice A. Dean Distinguished Professor of Constitutional Law at the Hofstra Law School in New York. He's a graduate of Yale College and Yale Law School. He clerked for Judge Irving R. Kaufman of the Second Circuit and practiced law in Washington and New York. He is the author of numerous scholarly articles, mainly dealing with the writ of habeas corpus, and I've read several of them, and they're outstanding. He is currently director and of counsel to the National Coalition Against Censorship, and is former chairman of the Communications Media Committee of the ACLU. Professor Friedman.
Okay. Now, with that introduction, it's particularly interesting that I find myself sort of in the position of the rabbi who had a couple come to see him, and the wife said, you know, my husband is absolutely terrible, blah, blah, blah. And the rabbi said, you're right. And the wife, the husband said, my wife, she's absolutely terrible. And the rabbi said, you're right. And then the wife came back and said, now hang on a second, we can't both be right. And the rabbi said, you're right. I find myself here, and it's one of the great pleasures of the Federalist Society and why you get so many kind of unusual suspects enjoying coming to these programs in a somewhat mushy middle of agreeing with some of this and not other of it. I start by saying that I absolutely agree with Judge McCasey that balancing tests, whether they come from judicial doctrine or are incorporated into statutes, are completely useless in trying to do what we're trying to do. Now, I reach a sort of different conclusion about the consequences of that, but he's completely right. The judges not only don't have any particular training or expertise, but in particular have an institutionally flawed perspective, because of course the judge always wants more information relevant to this case and this matter, and that's perfectly understandable. And the result is that the longer term interests which are being served, namely half a loaf is better than none, we want the information at least to be out, even if we don't know the name of the source, because the next time you're going to get neither the information nor the source. And that is not a perspective that is likely to be taken by anybody who is presiding over a real case. It's exactly like, you know, you're trying hard to control your weight, and the waiter brings some very tempting dessert, and you're supposed to say, well, I understand that the long-term consequences are very bad, and so I'm sending the dessert back. And at least in that case, you would be feeling the long-term consequences, whereas here we're talking that the long-term is that in some other future case, information is not going to come out. And therefore, as far as I'm concerned, the solution is that any statutory privilege that's created be absolute in the area that it covers, and balancing tests go away. And absolute, to me, means absolute, just like any of the privileges that Professor Volokh mentioned in attorney-client, for instance. What absolute means is the government does not get it, much as they would like it, much as it's very relevant, so on, unless the attorney is a participant in the crime, meaning shares the criminal intent of the client, which is rarely the case, of course, for ordinary journalists, but, as has been suggested, is a major problem in leak investigations, because giving the material to the reporter is itself the crime, and so you have the government always being able to say, well, the reporter is a participant, if not at least a witness. You wouldn't say that if the facts were that the lawyer's client led him to where the victim's body was buried. In fact, there's a pretty famous case in which the lawyers got ethics awards for precisely keeping that information confidential. So I would certainly say that the privilege has to be absolute in situations where the only crime is the revelation of the information itself by the source. And I'm not sure law enforcement would lose much by that, because the truth of the matter is that technology at the moment is making much of this part of the discussion irrelevant. It used to be the US government was very big, it was very hard to know where the leak came from. Nowadays, NSA knows everything about everything. It's not very difficult to find out the information flow, at least not nearly as difficult as it used to be. And this is analogous to attorney-client privilege because it's the system that's being protected. We talk sort of vaguely about, you know, the public interest in the information. Let's be a little more concrete. If there were no leaks, Congress would be out of business in terms of executive branch oversight, or at least 100% vulnerable to whatever the people briefing them choose to tell them or not tell them. And in fact, John Candy, subsequent to the Bay of Pigs, said, I wish we had not put pressure on the New York Times to keep that out of the papers, because the resulting public outcry might have saved us from a very serious mistake. And as to the executive, much of what the president learns, he reads in the newspapers. Again, John Candy used to say that I learn more from the New York Times than I learn from my CIA briefing. And I know some of you people believe in a unitary executive. Ask any president of the United States whether there's a unitary executive. Right? There are thousands and thousands and thousands of people pursuing their own agendas, much of which the president finds out by reading in the papers. So, as to Judge McCasey's thing about, oh, yes, and it's terrible how the Obama administration has leaked all its successes. Assuming that to be true, it's not something that was invented by the Obama administration. In fact, one influential document in the Pentagon Papers case was the very long affidavit of Max Frankel describing at length the practice of government leaks for the purpose of advancing the agenda of the incumbent administration. And again, more information on public affairs is better than less. And that's not just true about public affairs. The president of General Motors is better off knowing that there's a problem than not knowing it. If there's an environmental violation, or if there's harassment, or if there's something in that empire, the information, half loaf's better than none. It's too bad you don't know the source. You want the information. And so I think because judges balancing in all those situations is likely to put the balance the wrong way, absolute privilege is the way to go. And there's a second reason that Judge McCasey also mentioned, which is, I know we're lawyers and we think that legal formulations matter. At the end of the day, the source is either going to trust the reporter or not. And this is not going to depend on whether there's a 3-part test or a 3.5-part test that has 1 prong and 2 forks. Without an absolute privilege, the only real protection is that the source believes that the reporter will go to jail for the cause and stay there. Well, going to jail for the cause, as with Martin Luther King, has power if there is sympathy on the part of the public for the underlying principle and the underlying cause. And in that respect, the extent that there's a public climate of unhappiness with government spying, government secrecy, so on, is good. Because it's not the lawbreakers who are supposed to be the heroes of the story. It's the number of public-spirited and innocent people, as Professor Volokh suggested, whose desire for anonymity is perfectly legitimate, as the Supreme Court has recognized in protecting the anonymous pamphleteer against a proposed regulation that the source of the speech has to be disclosed. And the reason Supreme Court recognized that is because truth will come from many voices. Journalists' choices about what parts of the Pentagon Papers to publish may be controversial and may even be wrong in some objective sense. But the aggregate social costs of moving the decision-making power from the individual to the government are too high in totality, regardless of what you might think about any particular thing, to which the answer is that, well, now, hang on a second, weren't the government officials elected? Well, fortunately, I've got a founder on my side by the name of James Madison, who said, a faction is a group, whether amounting to a minority or a majority of the whole, whose decisions are contrary to the long-term aggregate interests of the community. That is to say, we've got to protect the minority voices because the underlying policy, though approved by the majority, may just happen to be wrong. And very often, that's precisely the conclusion that comes from leaks. Okay, so what's the path forward here? As everyone agrees, the current Supreme Court is completely unsympathetic to the concept of a First Amendment privilege, and so will all future courts, their judges. The common law privilege has power because, indeed, it's been, there's a lot of state and lower federal court law supporting the privilege, but it's the wrong kind of privilege. That's balancing test all over again. And so even if the common law argument had not been wrongly dismissed with the back of the hand in the recent James Risen case, I don't think it's got long-term future. And that does leave a statute, which makes sense, because often the reason you have a statute is to do something that you can't get under the Constitution or the common law, but it's got to be the right kind of a statute. No matter how, shouldn't be going for breadth, it should be going for strength. Whatever it covers, it's absolute. Otherwise, as with the various bills in Congress now, you've just made a bad situation worse, because Congress will announce that it solved the problem and go off to do other things, while the judges will just keep doing what they're doing, exactly as Judge McCasey said, which at this moment means acting like government officials and panicking when they sense that power may be dispersed and information may be getting out of control. So that leads me to the final minute and a half, which is on prosecution of reporters, as Adam said, not keeping their sources out of jail, keeping themselves out of jail. And there, I actually have no problem agreeing with Judge McCasey, because, yeah, if you want to prosecute the publication and undertake the legal, political, public opinion, and jury problem of proving criminal intent on the part of the publication, go right ahead. And in that respect, there is already a layer of protection, as was briefly alluded to by Adam, that there are a number of cases involving leaks from confidential judicial disciplinary proceedings, confidential juvenile proceedings, release of records of a rape case that ought not to have been released, in all of which you could not hold the reporter liable for what was an innocent disclosure, innocent in the sense that, yeah, the reporter may know perfectly well that the source acted illegally, but the reporter was not acting with any malicious intent. And the Espionage Act says, with intent to harm the United States. If you want to prosecute the New York Times under the Espionage Act for leaking the Pentagon Papers with intent to harm the United States, as I go right ahead. I have no constitutional law problem with it. And it may seem a little strange, to be challenging the government to hit you with a nuclear weapon, but, there's something to be said for nuclear weapons, which is neither side uses them. It keeps, the press on a certain side of the line keeps the government somewhat backed off, because I do agree with what everybody has said, that the situation over the last 35 years or so has been a kind of rough accommodation of work it out and we'll give a little, you give a little, and that has frayed so badly in recent years that we may be better off acknowledging that, in fact, the two sides are at war with each other, and at least get the restraints of use of force in war, rather than a set of agreements which neither side is now keeping.
Before we take questions, do any of our panelists would like to comment? General McCasey?
Just two small points with regard to the last points that were made. The espionage statute says with intent or reason to believe. So you don't need specific intent to harm. All you need is reason to believe that harm will result. And I would suggest that there have been a number of disclosures that were made with a reason to believe that harm would result. I also agree that there is no way that a prosecution would be undertaken in those cases except in the most extreme situations which we haven't faced. So far as an absolute privilege is concerned, you then get to the issue of defining who constitutes a journalist. And that in itself is something I would not want to see either legislators or courts do, in large measure because not only because they would be overly inclusive and not inclusive enough. Not inclusive enough by not including people who like to publicize things and devote a great deal of attention and effort to it, although they may not earn their living doing it. And over-inclusive by including, for example, correspondents of FARS, the Iranian news agency, Xinhua, the Japanese news agency, and to date myself, TASS, the old Soviet news agency, who were intelligence agents. They were regularly credentialed to come to the United States as journalists because it was known that they would occupy a privileged position with respect to information gathering. And so far as whether the Obama administration invented leaks, I willingly acknowledge that they did not. But when it comes to leaking information that is potentially injurious to national security, I think it has reached an absolutely unprecedented level, at least in my experience.
Sorry, no. After you. So I sympathize with a lot of the arguments for openness, but I sympathize with a lot of the arguments for secrecy, too. There are a lot of things that...
He's a law professor.
So there are a lot of things that we rightly expect the government to keep secret. It's a federal crime to leak tax information. And I'm not saying necessarily this means that a reporter who gets some tax information and decides to publish it should be liable. I'm not sure there is a federal statute that covers the reporter in that situation. But if a reporter were to call up an IRS agent saying, you got anything for me on politician so-and-so or actor so-and-so or my online critic so-and-so? Yeah, sure, here it is. Do we think that openness is so valuable that that should be protected and that the reporter should not have to reveal the name of the person who leaked that to him? I'm skeptical about that. Likewise, we are all lawyers, and if somebody were to if somebody were to try to get information from our staff or our paralegals or our secretaries about some famous client, I think we'd be screaming bloody murder. And I think we'd be right, and I think we'd be right in trying to go after this person for trying to get this information, even if he's arguing that A, it's of public interest, and B, maybe even he thinks, and we disagree, that this reveals some sort of shenanigans on the part of the trial team that's not properly disclosing certain information or what have you. In a criminal case, or for that matter, in a civil case, where there are all sorts of allegations of such shenanigans levied against law firms, rightly or wrongly all the time. So I would like to think that there would be some continuing protection for that, protection in the form of both going after a person who deliberately solicits the revelation of information that he knows would be either criminal or tortious, and protection in the form that if we're going after the suspected leaker, we can get the only other witness to the crime, that is to say the reporter, to actually testify about that. Maybe it's impossible without shutting off too much valuable information about all sorts of important things. I don't know, but I don't think we can dismiss the confidentiality interest that easily.
May I? I'm sorry, Adam.
I think Adam.
Yeah, Adam.
So I first of all want to disassociate myself with Eric's suggestion that the Obama administration should please prosecute the New York Times. Don't bring it on. I also want to make a pitch for half a loaf. I understand that in the pure good of theory, an absolute privilege would be a wonderful thing. A, it will never happen. B, it can't be absolute because it will at least be overcome by a Sixth Amendment fair trial right. And C, there's a lot to be said for being able to make your pitch, not only to a prosecutor as a matter of prosecutorial discretion, but a judge on some balancing basis. And even the prospect of satellite litigation over this question can be very valuable. Time is your friend. The underlying case may plead or settle out, and publicity will be brought to bear, and that can influence conduct. So I think there's more than a little to be said for getting something rather than nothing out of a shield law.
Okay, on that, we kind of sort of agree to disagree as to balancing stuff. But on Judge McCasey's point about defining journalists, that's an absolute serious concern that every statutory proposal has to face. All I can say is that it has been confronted and dealt with one way or another in the 35 states and whatever it is, 8 circuits that do recognize the thing, so it's not insoluble. And then on Professor Volok's tax example and the example of people trying to get information from your paralegal and so on, that's what we mean by the dispersion of power. That is to say, if the reporter calls the IRS agent and tries to get the tax returns, first of all, Justice Brandeis would say, yeah, prosecute the IRS agent. But leaving that aside, then what the system is we are, yes, indeed, relying on the good sense and of the journalist to choose what to publish, and the journalist may make wrong decisions, but that's the balance that's been struck. For example, in Gene's paralegal example, it's a closely adheres to the facts that some paralegal, in gross violation of duty of confidentiality to the firm, revealed all kinds of purported misconduct of the firm in discovery in the tobacco cases. Okay, that was outrageous behavior on the part of the paralegal, and rightly got the lawyer and law firm outraged. That doesn't mean that the reporter did anything wrong by publishing allegations of gross wrongdoing that never would have come to light, and that the public, in fact, didn't benefit from it. And those are very much two different ideas which I think we need to keep separate.
I think we'll take questions if the floor is open.
I'm curious to get your views about how far one goes in terms of being a journalist, whether a blogger or whatnot might fit into that category. And I'm also curious, you made this distinction between somebody who's a passive recipient of information versus somebody who goes out of their way to procure it in some way. Although I think, Eugene, you said it's the bread and butter of reporters to call up and flatter people and cajole them into, they're not paying them a bribe or extorting the information, but they're doing an awful lot of stroking to get that information. And I'm curious to get people's views about when you cross that line.
So let me turn to the first question about who's a journalist and how that can be defined. I actually wrote a long article talking about the First Amendment issue, and I think I've demonstrated that from basically before the framing up until 1970, there is no authority whatsoever for the proposition that the freedom of the press somehow specially belongs to institutional members of the press. That all the authority was that freedom of the press belongs to anybody who uses the device called a press, and by extension, other similar devices. Could be the internet, could be a wide variety of other things. Then starting 1970, there have been a handful of lower court cases that have said, oh, well, the institutional press gets better protection, and a few hints about the possibility of that from Supreme Court opinions, and many more holdings to the contrary from Supreme Court opinions. So it seems pretty clear as a First Amendment matter that there can be no distinction between journalists, professional journalists and others, and indeed the circuit courts that have recognized the privilege as a First Amendment matter have all made clear, or I shouldn't say, those that have then been asked, well, who's covered, have all made clear that you don't have to be employed by a newspaper. You could be you could be a political organization. You could be a freelance book writer. You could be a couple of academics trying to make a documentary. However, as a statutory matter, it turns out that many statutes, some statutes define things very broadly. California is one of them. Some define it much more narrowly. Delaware, I believe, has very specific rules that govern, that require that you make some amount of money, or excuse me, not some amount of money, but that you have made money from this for at least 3 of the last 10 weeks or something along those lines. And statutes are entitled to draw those kinds of distinctions. The question is, what's a sensible distinction? I mean, to draw the distinction between a journalist and a blogger is a funny thing these days, given how many journalists have blogs, how many bloggers become journalists, and how many blogs are bigger than many a newspaper, and more useful than many a newspaper. So I'm completely unbiased in this. So I think as a statutory matter, one could draw the distinction, just very hard to come up with really plausible distinctions, especially ones that are written today as opposed to some 20 or 30 years ago where the lines seem to be a little bit sharper. As to the line between what is traditionally just criminal solicitation, I was a little puzzled by Eric's point that the reporter, maybe I misunderstood Eric's point, but as I understood it is that the reporter shouldn't be held liable even for calling the person and asking him to leak things. You know, under standard criminal law, that's solicitation of a crime. It's just hard for me to see what would be the distinction under ordinary criminal law between soliciting that crime and other crime, as opposed to, say, a matter of prosecutorial discretion, or as a First Amendment matter, if what you're soliciting is constitutionally unprotected conduct, which by hypothesis the leak is going to be. So I think that that's a very hard line. But once one gets away from the hardcore solicitation, it does become a very hard line to draw because of the way conversations often go. Setting aside the situation where you just get something in your mailbox and you publish it and you never once talk to the suspected source.
Eugene's constitutional analysis about the meaning of the press clause seems right to me. I do think that it's possible to define through some kind of functional way who is gathering and disseminating information for the purpose of informing the public. It is the case that as a practical matter, the Supreme Court decides who is and is not the press who gets to sit in the good seats. So it's not that it hasn't happened, and it's inconceivable to happen. So I think that can be overcome. As far as whether ordinary news gathering conduct amounts to solicitation, I don't think that's a serious problem. I was this morning just reading a federal judge's blog. Did you know there are such things? Judge Kopp in Nebraska has an excellent blog. And he wrote that one of the lessons of the back and forth between the Second Circuit and Judge Schindler in the stop and frisk case was that a good journalist's job is to make you say things you will regret.
Well, a prime case, if I can just add a footnote to illustrate both of your points, is New York Times versus Sullivan. People forget that there were individuals involved in that case who bought and composed the ad, Heed Their Rising Voices. And the opinion by Justice Brennan, one of the leading First Amendment cases, drew absolutely no distinction in terms of the First Amendment between the New York Times on the one hand and the individual defendants on the other. So
yeah, and some months later was Garrison v. Louisiana. New York Times v. Sullivan applied. The guy was a politician. A year later, Henry v. Collins, some crank who started sending out press releases to the AP and various other services. New York Times v. Sullivan applied. Very solid.
let me just throw out one other thing that's triggered by the solicitation comment is, I have really never understood suppose that the leakers in general commit not one crime, but two. The first is acquiring whatever the document is, which is in the nature of a theft. And the second is disclosing it. What I've never really quite understood is why, if, for example, the document or whatever is a tape or a CD or a DVD, something that is physical rather than just word of mouth physical, and somebody breaks in to a government office and takes the DVD out and then gives it to a reporter knowing that the DVD is stolen, why the reporter is not guilty of receiving stolen property. I don't understand that. And there are many of the hypotheticals and actual cases that seem to fall within that particular hypothetical.
Well, that was very much the subject, wasn't it, of your decision in Boehner against McDermott,
Right.
the en-banc decision, which divided the D.C. Circuit quite closely. And I think Judge Santel's response might be, Well, does that mean at every link of the chain? So somebody gives it to the reporter publishes it, somebody repeats what they read in the newspaper over the breakfast table, that person, each of those things is a crime?
Yeah, well, that's, that's a line drawing thing, and we have a solution for it in the criminal law in the Fourth Amendment cases, which is that the taint gets dissipated the further out you go.
Right, I say the taint gets dissipated when the material arrives to me.
Well, and he has support for that in the rape case, right? The guy who handed over the court records was committing a crime, but the reporter was not.
It doesn't, by the way, apply in, we hear cases all over the lot, as Judge McCasey, we've had some child pornography cases where the individual who does the filming is obviously guilty, but every single person that downloads that image is also guilty of a crime. So.
But I would think that child pornography is special in part because while it's not an element of the test that it has to lack serious value, one of the reasons the court gave in New York v. Ferber for treating it this way is precisely that it lacked value.
This is one of the areas that Gene just mentioned that makes so much of First Amendment law incoherent. The Supreme Court again and again tells the state legislatures and the Congress that if they draw a law that's not content neutral, it's going to violate the First Amendment unless they're compelling interests the other way. And then when the Supreme Court decides cases, they decide them on the basis of content. Is this of public value? Does this have artistic merit? I mean, all of that is content-based. Anyway, next question.
Thank you. Oh, I'm sorry. Thank you for your presentations. I'm merely a law student, and actually I'm studying evidence right now. And my question...
I'm sorry, are you maybe studying a little too close to the mic?
Yeah, it's
or
hard,
too far?
hard to
Hard to tell.
understand.
Somewhere.
Can you hear me now?
Somewhere else is better.
There we go. Okay. I'm studying evidence right now. I'm in law school. And my question is in regard actually to the principle that privileges stands on, that the state has a right to the testimony of every man, individual. And that I don't understand, and I was hoping you could enlighten me, because it seems like on what authority that could the state make such a claim, because especially in light of our society now and how much privacy is emphasized, because what is more private than the thoughts of every man, and to think that the state has a right to them.
Whoever has the best hearing will answer that question.
Oh, no, well, the question was, what's the foundation for the principle that the law is entitled to every man's evidence?
Oh.
Which I take it the answer is history and practicality, but, you could write books about it, and probably people have. It's because that's the way it's always been.
I was going to say, perhaps because there are the inverse canons that you don't have to testify in certain circumstances. By implication, you have to in others. I actually think that the point of the rape case incidents is very important, because other than many of these cases, which are cast as Article I actions that are being adjudicated by a purportedly independent, Article III tribunal, there you have a potential breach, although it may be relevant to a law duly passed, but not always. There you have essentially a breach of confidentiality coming out of Article III branch itself, if I understand how the case is.
No, that was Florida Star v. BJF. It was a police officer in Florida who...
Oh, it was a police officer. Okay, I apologize. I wasn't sure who did it. I only thought it helped my question to come more precisely on point here. But we do hear this almost as if Article III tribunals would be, abstracted wisdom, applied, whether it's through a balancing test or an absolute statute guiding them. But I've observed in terms of people's, access to criminal enforcement, which I think includes effectively adjudication, that sometimes access to court materials and court proceedings is very restrictive, or effectively restrictive, in the sense that if you try to get the records of records continue to be kept as little transcribed things, and if you have $1 million or there's an appeal, that little transcribed thing will be made into something that a reporter could read or that the public could read. And when I saw the subject of criminal enforcement, and reporting, I'm very concerned that there's not more pressure from reporters. So maybe it's a question of Adam, or there doesn't appear to be, to have access to these materials of the adjudication process. Unless you happen to be the reporter in the courtroom at the time it's happening, I found that it's very difficult to fight through the kind of bastion that the third branch actually erects in front of these materials.
So you're making a couple of practical points, which I'll address in a second, but I actually think the basic legal principle goes the other way, where somewhat surprisingly, the court has said that not only the Sixth Amendment, which guarantees open trials, but also the First Amendment, which really doesn't speak to access to information, guarantees a right of access to almost every part of every criminal and civil proceeding, so long as the materials are submitted for adjudication. As to whether it's hard to get a hold of them, sometimes you have to go to the courthouse. It's also the case that the press, now that we're struggling to survive, is not a proxy for the public the way we are a couple of decades ago, where we really pressed access issues as a matter of principle, even if there were not a story on the other side of it. But I think this, compared to other legal systems, is actually a good news story. Materials submitted to courts and court decisions in the United States really are almost without exception open.
And I undertake this only because we've had to file FOIA requests to get them in the Southern District of Ohio in cases. It's been very, very difficult. So I raise it. I realize I want to let other people ask questions.
I wonder how much of that has to do with the practice of transcripts being prepared after the fact by court reporters, and court reporters having kind of quasi-proprietary rights just so they get paid, so you can't really get the transcripts. I wonder how much that's the concern. Because I do think it's true that often the transcript is actually not prepared until much later, and I don't think the original notes are matter of public record, usually as a practical matter.
Typically on PACER, which itself requires the payment of a fee, which I think is problematic. PACER is the federal court electronic filing system. Transcripts are usually not available and usually require a separate fee to a private entity, and that strikes me off the cuff as deeply problematic. Some courts do have a practice, though, of limiting in time and posting eventually the transcript, because the people who will pay for it are typically the parties, the lawyers, and at some point in time, nobody's going to pay for it anymore, and you might as well make it public then.
Well, I was just going to say that I think Adam may be a little too optimistic here. And I think the judges on the panel may support me about this. There do exist secret dockets in the courts, which was a long-term practice in terms of mafia and so on, which has expanded radically for national security purposes, to the point where people are filing sealed cert petitions in the United States Supreme Court. And there are more and more parts of the judicial records which not only are sealed and then the press could go try to unseal them, but there are whose existence isn't even known. And I can't tell you about it because I don't know about their existence, but I think some of the judges can tell you that that's correct.
In my old court, the existence of a document had to be made known. Documents, however, were sealed, transcripts were sealed, and proceedings were sealed, and I held a number of them myself and required a finding that there was a good reason, usually because somebody was likely to get killed if you didn't seal it.
Yes, sir.
I mean, just as an example, you have a mafia case and one defendant pleads guilty. You enter an item on the docket that says Mr. X pleaded guilty, and you better believe that members of Mr. X's family are going to be in mortal danger if that docket entry gets out immediately. There's every good reason to seal it.
I was wondering what the thoughts of the panel were on, this seems to me to be intersection of the kind of a right to anonymous publishing, being able to speak anonymously, and the fact that the founders, when talking politically, like through the Federalist Papers or everything, almost every one of them was using a fake name or done without any name attached to it. And secondly, do we know really that the person who gave the information in these leak cases to the reporter was breaking the law? Because obviously someone broke the law when they disclosed it, but it could have gone through 2 or 3 hands potentially before it gets to the reporter. So we, at least in my opinion, don't really know that the person who gave it to the reporter was breaking the law.
I'll save the second question for others, but the first question, I think, in some measure conflates 2 separate issues. One is, can the government prohibit the publishing of certain things unless the published thing has a name attached to it? There had been lots of such laws. They were struck down first in Tolley, California in 1960. That was reinforced in McIntyre v. Ohio Election Commission in 1995, where this whole original meaning question was debated between Justices Scalia and Thomas. There's an exception to that in the election campaign context, where court has upheld without very deep discussion the requirement that broadcast ads, if I recall correctly, include the name of the funder right on them. But as a general matter, you have the right to talk anonymously in that you can't be punished for talking anonymously. It's a whole separate question whether you have the right to insist that your anonymity be retained. If I hand out leaflets that are defamatory of you, I can't be prosecuted because I didn't sign my name to them. But if you want to sue someone for libel and you don't know whom to sue, but you think the printer might say, oh, that was Volokh that came in and ordered it, or the printer's records might reflect that I paid for him, or these days what it is you go after the internet service provider to try to track down the identity of the poster. I don't think the court has ever suggested there's some absolute privilege, or any court has ever suggested there's an absolute privilege not to have your identity be disclosed, even if there's a prima facie case that what you did is civilly actionable or criminal. And I think that's got to be right, so long as you think there's any role for libel law or for threats law or whatever else. If I publish something that is threatening, then presumably the government could go and subpoena the service providers to get my identity. So I think the right to anonymous speech, which the court has upheld, is just a right not to be punished for the anonymity. It's not a right never to have that veil of anonymity pierced.
So how does, I'm sorry.
Yeah, you were very charitable when you mentioned the Supreme Court's opinion in McCain-Feingold, saying they didn't give much of it. They gave 0. I am John Q. Smith, and I approve this ad requirement. There is a line of Supreme Court cases. City of Stratton comes to my mind, McIntyre. This line of cases that say that you have a First Amendment right to speak anonymously. In those cases, the Supreme Court never even attempted to distinguish any of them in McCain-Feingold upholding the disclosure statute. I'm sorry.
I was going to ask the same question of Eugene, of how does Doe v. Reed or Citizens United, which seems to say that some political speech can be conditioned on disclosure, fit into your analysis?
I think that Doe is a separate question. I'm actually with Justice Scalia on that, although he was not entirely in dissent, but certainly not in the majority. I think that the government can require that you identify yourself when you're signing a petition. In fact, you kind of have to identify yourself to the government. And at that point, I think if a government wants to say, look, if you want to take advantage of this procedure, we're going to reveal it to the public at large, I don't think that's a limit on your anonymous speech. It is a limit on your anonymously participating in this lawmaking process, but I don't think you have any right to anonymously participate in that. That was Justice Scalia's point, which I think was correct. The majority said, well, you have a conditional right, but it's easily trumped. Query whether that's sound. But as to the other point, the requirement that you identify yourself on certain kinds of political ads, that certainly is an interference with the right to anonymous speech, but the court has always justified that as an exception, as a strict scrutiny justified exception. I agree with the judge that it didn't explain why strict scrutiny is best here, but it certainly tried to cabin it to that. So as a general matter, the tally line of cases still remains just with this carve-out, I think.
Yes, sir.
Cameron Smith from Alabama. I see my government growing and my media with the good seats shrinking. And so I'm thinking more and more about, what is the role of the press in these types of things? And what information I really want to know as a citizen. What do y'all think about a safe harbor from prosecution relating to a reasonable belief in exposing a constitutional or criminal violation. This is materially different than, say, individual information that's just there for the sake of wanting to put stuff out there. But if there is a reasonable belief that a government actor or actors have engaged in criminal or unconstitutional activity, that could be a bar from prosecution.
So that would seem to encompass Snowden, yes? Or Manning, or whoever leaked the warrantless wiretapping program to us in the early 2000s. I welcome judicial comment on that.
I'm not a prosecutor, so.
I always thought that was what prosecutorial discretion was all about, and putting it in a statute I don't think would enhance it substantially, other than to have it reviewed by a judge.
Don't some whistleblower statutes, I'm not at all an expert in them, but don't some whistleblower statutes try to draw that kind of line, at least as to certain kinds of revelations? And
They do, but the question embodied in the question is disclose to who? And if you disclose you report within the government actions that you consider fraudulent, that's one thing, but to spread it on the front page of the New York Times may be something quite different.
Well, there are employment discrimination statutes that contain that exception. This comes up from time to time, interestingly, in lawyers' ethics cases. If you're fired from the law firm because you blow the whistle on the law firm for some misconduct, there are some cases in New York, actually, I think, applying a statutory protection.
But to answer your question about Snowden, the thing that I envisioned was if he would face prosecution, but in the event that he could convince a judge or jury that he acted in a reasonable fashion based on a reasonable belief that he could not be prosecuted, that's different than prosecutorial discretion because it could be reviewed.
Then he may not be guilty anyway.
You know, it's a curious thing, among other curious things about the First Amendment, that oftentimes you as the speaker have to make a judgment about whether you're doing one of two things, giving the same speech, whatever it happens to be. You're either committing a criminal offense or you're engaged in the very high-falutin sounding freedom of speech. And oftentimes you won't know until you've given the speech and you are either indicted or not.
Yeah, that's what Eugene Debs discovered.
Yeah. And Schenck and Frowork and all the other cases that Holmes upheld convictions in. So. Anything else? I guess any closing comments? Gentlemen? Okay, I guess we're finished.